Um, any questions as I discussed day before yesterday, अगर कोई questions होंगे हमारे law general के ऊपर तो हम आज थोड़ा सा time लगाएंगे उसके ऊपर. Any questions that you came up with after you studied or after you thought over whatever we discussed day before yesterday? वैसे तो दिन भर क्लास चलती है तो रिवीजन करें कब और कब साइड में पढ़ें ये तो एक इशू है ही. But anyways, anyone who has any question that anyone came up with or has thought about it, we can address it. So, आज का जो सब्जेक्ट है हमारा रियल एस्टेट लॉज का, आई थिंक दैट इज क्लोज एट हार्ट फॉर एवरीवन. It has a direct implication for all the valuations that any land and building valuer needs to do. The legalities of the legal background, the legal requirements, the legal rights, legal duties have a very, very important bearing on the value that anyone can perceive. So एक example काफी बार दिया जाता है कि एक land and building है owned by an individual and it is in possession of that individual. So the value of that property may be very, very different as compared to the same property, the same structure, the same details, but where the property has been leased out. So suddenly the value will change. Why? Because the changing scenario is the right that or right or duty. It can be a right or a duty also. So the owner of the property, if he has leased out some premises to somebody else, then the right is to collect rent, right? But at the same time, that right may be a duty. Why can it be a duty? Maybe the market rent is way higher than the current lease rate or the rate that has been fixed for the rent of that property. In that scenario, so similarly, there are easement rights, there are right of way, there is then documentation. So we will be focusing on a lot on Transfer of Property Act and how what documentation needs to be there for you to understand if the proper legal ownership is there with the person who claims the ownership or not. If a property involves a will, a property involves inheritance, what does that involve? So we'll be discussing about all that. I'll just share my screen. So I think Sandeep ji was already talking about what all we will be discussing, but we will be discussing about land acquisition. Why land acquisition by the government is a very, very important subject for valuation purposes. It involves a lot of valuation work. It involves a very, very interesting definition for market value. It also provides opportunities for valuers, and therefore this is an important part that we need to talk about. We need to understand the basic statute. हमें पता होना चाहिए कि स्टैट्यूट के अंदर क्या चीज़ें लिखी हुई हैं ताकि हम उसके बेसिस पे मार्केट वैल्यू कंप्यूट करें अगर कभी हमें करना हो तो. how are the structures valued, how is everything done, हम उसकी बात करते हैं. जनरल बिल्डिंग रूल्स एंड रेगुलेशंस के बारे में थोड़ी सी बात करेंगे. रेंट कंट्रोल लॉज के बारे में बात करेंगे. हाउ रेंट कंट्रोल लॉज इम्पैक्ट वैल्यूएशन. आई विल रिक्वेस्ट ऑल दी पार्टिसिपेंट्स टू share their experiences with rent control laws and how they ended up changing the valuation because of rent control laws. Right of way, section 52 of Easement Act we will discuss. RERA discuss करेंगे briefly and how it has impacted the real estate industry. We will also talk about Transfer of Property Act, including all these sections. We will talk about laws relating to inheritance succession. So land acquisition का जो लॉ है बहुत बहुत पुराना है. Going back to 1894, that is when we have a Land Acquisition Act, and if I'm not wrong, then land acquisition must be happening even before that, because the basic premise is that the private ownership or private use of any land that use is always understood to be inferior to the use or the required use of the society. So what are we doing through this act? We are saying that whenever there is a public purpose for which a land is required, the government has been given the right to take that land, to acquire that land, and pay a compensation, rehabilitate the person, So this is what is required, and this is what is proposed in this act. This 1894 Act was replaced by this 2013 Act. I remember that when this 2013 Act was coming, there was a lot of political and other discussion that happened on this subject, because land acquisition is also very, very important and a very, very crucial political subject, and it has a lot of bearing on vote banks also. The new act came into force on 1st January 2014, and it was also extended to JNK by the JNK the recent act, when the constitutional change was also done, where the act is now applicable to the whole of India, including JNK. So when we look at the preamble of this act, we need to understand, so as we understood day before yesterday, that the preamble of the constitution, the preamble of any act, talks about the purpose of the act. And we need to understand that, yes, the purpose of the act, the requirement of the act, all that is discussed in the preamble. So when we say that this preamble, when we read this, we first of all read this part, that an act to ensure, in consultation with institutions of local self-government and Gram Sabhas. So the act starts with saying that whenever there will be a land acquisition, or whenever there will be a proposal for a land acquisition, the government will attempt to consult the institutions of local self-government. What are local self-government institutions? Panchayats, basically panchayats, gram sabhas. So they are also are established under the constitution. So then it says that to provide a humane, participative, informed, and transparent process. So I think if we talk about the process of land acquisition, we will like the land acquisition process to be human. It should not be an inhuman practice that you just snatch somebody's land, because somebody's land is not only it may have monetary value for that person in the terms of market value, but it also involves somebody's emotions. It might also involve somebody's way of living, which might change dramatically in case you take away that land from somebody. Participative, informed, transparent process. For what purpose? Now, this is important, that for industrialization, for development of essential infrastructural facilities and urbanization. So what are we taking away the land for? We're taking away the land for industrialization, development of some essential infrastructure facilities, and urbanization. These are the objectives. What are we doing? What are we with the least disturbance? So we are saying that we don't want to disturb too much, and we don't want to disturb the affected families, and we want to provide just and fair compensation. And then we also want to talk about rehabilitation and resettlement for those people. So once you pay somebody any compensation for the land that he owned, you also want to take care of the fact that that person is able to resettle. That person, once he moves out of that land, is able to find land or find some place to settle again. So it is important. If somebody was doing, maybe agriculture, and that person was doing agriculture for a specific crop, now you tell him that you sell your land. So now he has to go to the market and maybe purchase somebody else's land, or you have to try and redevelop some land which was not earlier the agricultural land and give that land to him. There are cases of land acquisitions that have happened for setting up hydroelectric power plants. What happens in hydroelectric power plants is that maybe there is a village, maybe there is some farmland that is part of the area that is proposed to be the catchment area for keeping water, which is required to to fuel the hydroelectric power plant. So what happens is that you have to displace those families, because those lands that they were using earlier for cultivation, for other things, will now perhaps be submerged under that pond, under that lake that is created because of the hydroelectric plant. In that case, you have to compensate for their loss of to destabilize them, and you have to rehabilitate and resettle them. And then it also talks about how the affected persons can be made partners in development. So there is always this, very, very great idea that in case somebody's land is acquired, then we talk about giving employment to one of his family members in the proposed project. Similarly, we can talk about giving that person or that community some shares in the project that is being set up. So basically what you're trying to do is you're making them partners in the whole project. You're telling them you're also part of this project because you have also contributed in this project by way of giving up your land. Yeah. So section 2 of the application of the act is a very, very important part because it talks about what purposes can this acquisition be done for. So basically it is basically dividing or basically telling you that this is the list of purpose for which land acquisition can be done under this act by the government. So it is a very, very important section. So to understand this has various legs. Most importantly, it has 3 legs. One leg is talks about how the first part talks about, the first subsection of this act talks about uh, uh, that it shall apply, that this act shall be used whenever the government acquires land for its own use, hold and control, including for public sector undertakings. So how have they defined it? The government is taking over this land for its own use, control, and holding the land, and it includes any PSU also. So in case tomorrow there is maybe a PSU like ONGC, it requires a land, the government can acquire it and the government can give it to the PSU, and that will be covered under subsection 1. And this is one part. This is about who will acquire or who will use this land. Now, for what purpose can this land be taken? So the first sub leg of this or sub part of this first part is strategic purpose. What can be strategic purpose? Strategic purpose can be naval, military, air force, armed forces of the Union, including central paramilitary forces, or any work vital to national security or defense of India or state police, safety of people. So this is all is covered. So whenever there is, this is a strategic purpose, and this is one part of one sub leg of it. The other leg of this is for infrastructure projects. And when we say for infrastructure projects, then there is an includes. So what does, whenever you read in any law, something which is defined and then you read includes, that means that this list is not exhaustive. This list it was only indicative. So the government can say that for infrastructure projects, they can acquire land under this act. When they say includes, they have included in this the various the activities or items listed in the notification of the Government of India and the Department of Economic Affairs, but they have excluded private hospitals, private educational institutions, and private hotels from this part. It's not that land cannot be acquired for private hospitals, private education institutes, or private hotels, but the land will be land for such private use will perhaps can be acquired under the second leg of this definition, which has a separate requirement. Projects involving agro-processing, supply of inputs to agriculture, warehousing, cold storage facilities, marketing infrastructure for agriculture and allied activities such as dairy, fisheries, and meat processing. So when we talk about agriculture, when we talk about the animal husbandry, we include all these things and say that any project which involves agro-processing or setting up any infrastructure for any agro-processing unit, which is any supply of any inputs to agriculture, all that can be, that those such projects can be, the infrastructure for such projects can be, any land required for the infrastructure for such projects can be acquired under this act. Project for industrial corridors or mining activities, national investment and manufacturing zones as designated under the national manufacturing policy. So what did we read in the preamble? We read that one of the ideas of or one of the requirements of making this going for this acquisition is that we're talking about industrialization. So this part is very, very important, because whenever you create an infrastructure for industrial corridors, mining activities and all that, when you're creating infrastructure, you're creating manufacturing jobs, you're industrializing the country, you're urbanizing the country. Then project for water harvesting, water conservation structures, sanitation, project for government administrated, government aided educational and research schemes of institutes. So please notice that these are only the project for government administered, government aided educational and research schemes, not for private institutions here. Project for sports, healthcare, tourism, transportation of space program, any infrastructure facility as may be notified. So then the government has kept a part in the seventh part that in case something is not already in the list, we can notify it and make it part of this list. Project for so then this is the second part. So when we talk about the first leg where the government can acquire the land, then we talk about the government can acquire land for project affected families. What does it mean? आपने एक प्रोजेक्ट लगाना है हाइड्रो इलेक्ट्रिक पावर प्लांट का. अब आपको लगता है कि जो लोग वहां से डिस्प्लेस होंगे, आप उनको एग्रीकल्चरल लैंड देना चाहते हो. Then you can also make a scheme to acquire land which is agricultural land from those people who have it. For what purpose? To give that land to those people who are affected due to this resettlement. तो आपने एक प्रोजेक्ट टेकअप किया, एक प्रोजेक्ट की वजह से आपने कुछ लोगों को डिस्प्लेस किया, अब आपको उन लोगों को वापस से सेटल करना है. तो आप ये भी कह सकते हो कि हम एक प्रोजेक्ट बनाते हैं जिसके अंदर हम जो और लोग हैं इस एरिया के अंदर जो ऑलरेडी जिनका लैंड नहीं हम बाय कर रहे, हम उनके लैंड को भी एक्वायर कर सकते हैं टू सेटल दीज अफेक्टेड फैमिलीज. प्रोजेक्ट फॉर हाउसिंग or such income groups as may be specified from time to time. So basically housing for such income groups. Why is income group important? Now if you say that I want to acquire your land to build houses for high class society or very, very expensive houses, then the government says that maybe there is no social purpose to it. Those people who want to construct very, very expensive houses can buy the land privately and they can construct it. But whenever we talk about public purpose, it requires public purpose attaches itself to income levels. So the income level has to be a lower income level for somebody to acquire it. So project for plan development or the improvement of village sites or any site in urban areas or provision of land for residential purpose for weaker sections in rural and urban areas. Project for residential purpose to the poor or landless or to persons residing in areas affected by natural calamities or to persons displaced or affected by reason of the implementation of any scheme undertaken by the government, any local authority or a corporation owned or controlled by the state. So this is the first leg. The second leg then talks about where that it says that the provision of this act relating to land acquisition, consent, compensation, rehabilitation and resettlement shall also apply when the appropriate government acquires land for the following purposes. What are the purposes? Purposes are public-private partnership, PPP projects. So whenever there is a PPP project, then this act, all the provisions of this act with respect to acquisition, consent, compensation, rehabilitation, all these provisions will become applicable even for that PPP project. For private companies, for public purpose as defined. So in case private company wants to set up an industrialization unit or industrialized unit in some rural area, then also this provision is available. What is the proviso? Proviso to this part of the section is that in case of private company acquisition, 80% of the people who are residing in that area should give their consent that we are okay with this land being used for this private purpose, and then only the government starts the process of acquiring the complete 100% land. अगर आप एक जगह गए, एक एग्रीकल्चरल लैंड, एक एग्रीकल्चरल बेल्ट में गए, आपने वहां पे कहा कि हम यहाँ पे एक फैक्ट्री लगाएंगे, इस फैक्ट्री में हम आपकी मे बी शुगर केन प्रोसेस करेंगे. लेट्स से अज्यूम दैट इट इज अ शुगर फैक्ट्री. शुगर केन अगर आपकी शुगर फैक्ट्री लगाएंगे तो क्या फायदा होगा कि आपको आज की डेट में हो सकता है दूर जाना पड़ता हो अपनी शुगर केन लेके, या कोई एग्जिस्टिंग यूनिट था जो बंद हो गया था, अब उस एग्जिस्टिंग यूनिट की जगह एक नई फैक्ट्री बनाने की बात हो रही है, तो आपको जब आप शुगर केन लगाओगे तो आपको ज्यादा पैसा मिलेगा, आपको मुनाफा होगा. तो हो सकता है वहां के कुछ लोग जो हैं वो कहें कि हाँ हम चाहते हैं कि आप यहाँ पे ये यूनिट लगाएं. तो वो कुछ लोग चाहते हैं, कुछ लोग नहीं चाहते हैं. there will always be some divide. Some people who will be dissent, who will say नहीं चाहिए हमें, हम जैसे हैं वैसे खुश हैं, हमें नहीं चाहिए इंडस्ट्रियलाइजेशन, हमें नहीं चाहिए प्लांट यहाँ पे, हमें अपनी जमीन नहीं बेचनी, अनसर्टेनिटी होगी, कुछ और होगा. तो उन लोगों के लिए गवर्नमेंट ने कहा है कि 80% of the consent should be there. Then only the government will acquire the land under this act and also acquire the land which is the remaining 20%. So the dissenting people also have to give assent in case 80% say yes. And in case of PPP projects, public-private partnership projects, private partnership projects, you have to similarly take 70%. तो उन्होंने रिलैक्सेशन दे दी कि क्योंकि पीपीपी प्रोजेक्ट है तो 80% नहीं 70% के ऊपर भी हम मान जाएंगे. प्लस ऑफ कोर्स सोशल इम्पैक्ट असेसमेंट होना चाहिए. शेड्यूल्ड एरियाज हैं कुछ जिसके अंदर आप एक्वायर नहीं कर सकते, कुछ उन्होंने ऐसे एरियाज रखे हुए हैं जो उन्होंने हटाए हुए हैं, ये वाली एक्विजिशन जो है वो इस एरिया में नहीं हो सकती. देयर आर सम शेड्यूल्ड एरियाज. This was the second leg. So what was the first leg? The first leg did not involve any 80%, 70% criteria, did not involve any social impact assessment criteria, did not have any scheduled areas. The second leg, which talked about some private acquisition for private use or for public-private partnership use, it talks about a consent system. Then it talks about the third leg, that is the provisions relating to rehabilitation and resettlement under this act shall apply in cases where a private company purchases land equal to or more than such limits in rural areas or urban areas as may be prescribed by the appropriate government through private negotiations with the owner of the land in accordance with the provisions of section 47. A private company requests the appropriate government for acquisition of a part of an area so prescribed for public purpose. Provided that where a private company requests the appropriate government for partial acquisition of land for public purpose, then the rehabilitation, resettlement entitlement under the second schedule shall be applicable for the entire area, which includes the land purchased by the private company and acquired by the government for the purpose as a whole. अब क्या कहा हमने? So what are the different legs now? So अगर आपने closely पढ़ा हो तो ये third leg is only and only applicable to the rehabilitation and resettlement part. Why? Because when a private company is acquiring land privately, then also what this act is doing is it is requiring that private company to or that private entity to pay whatever compensation is stipulated for the rehabilitation and resettlement. तो जब किसी की लैंड एक्वायर होती है तो उसको क्या क्या नुकसान होते हैं? सबसे पहले जो है उसका नुकसान होता है कि उसका लैंड का जो मार्केट वैल्यू है वो उससे ले लिया गया, राइट. नंबर 2, उसका क्या नुकसान होता है? उसको हो सकता है कोई डैमेजेस हो उसके, कोई उसके ऊपर जैसे लैंड के ऊपर कोई बिल्डिंग खड़ी हो तो वो बिल्डिंग भी उसकी जा रही है या बिल्डिंग डिमोलिश होगी या बिल्डिंग जो है उसको इट विल नॉट बी इन यूज. देयर कैन बी क्रॉप्स. अगर एग्रीकल्चरल लैंड किसी ने लिया और ऐसे टाइम पे लिया जब क्रॉप्स थे उसके ऊपर और वो क्रॉप्स भी हम हटा नहीं पाए, ठीक से हार्वेस्ट नहीं कर पाए, तो वो डैमेज भी मेजर होना चाहिए. देन वी कम टू द रिहैबिलिटेशन रीसेटलमेंट. तो गवर्नमेंट कहती है कि आप किसी की लैंड एक्वायर करके उसको छोड़ नहीं सकते कि अब तुमने हमें कंपनसेशन दे दी है तुम्हें तुम्हारे इस लैंड को लेने की वजह से, अब आप अपना काम देख लो, आप देखोगे आपको कैसे अब इसको मैनेज करना है. गवर्नमेंट कहती है तो आपको उनको रिहैबिलिटेट और रीसेटल भी करना है. आपको कोशिश करनी है कि उनका लाइवलीहुड जो है वो खराब ना हो, उनका लाइवलीहुड कोई ऑल्टरनेटिव लाइवलीहुड मिले उनको. अगर किसी का लैंड छीन लिया गया है तो उसको नौकरी मिले, उसको किसी और तरीके से कंपनसेशन मिले. कुछ डेफिनेशंस, इंपॉर्टेंट डेफिनेशंस को डिस्कस करेंगे that because these definitions are important because we need to understand these definitions primarily to understand that who are the people we will be compensating. अगर लैंड की बात करेंगे तो लैंड की तो लैंड किसका होगा, उसके रिलेटिव्स कौन कौन काउंट किए जाएंगे, फैमिली का मतलब क्या होता है. क्योंकि जब आप इसको देखेंगे, इसको एक्ट को कभी आप इस एक्ट में काम करना चाहेंगे तो आपको बेसिक्स पता होने चाहिए टू वर्क ऑन दिस एक्ट, अंडर दिस एक्ट. Affected people include a family whose land or other immovable property has been acquired. Then it includes a family which does not own any land, but a member or member of such family may be agricultural laborers, tenants, including any form of tenancy or holding of unsuffered right, sharecroppers, or artisans. who will be working in the affected area, who may be working in the affected area for 3 years prior to the acquisition of the land. हमने क्या कहा, हमने कहा कि सबसे पहले तो जिनका लैंड है, फिर हमने कहा कि जिनको जिनको कोई टेनेंसी के अंदर वो लैंड मिला हुआ है, या जो लेबरर हैं, एग्रीकल्चर लेबरर हैं जो उस लैंड के ऊपर काम करते हैं, उनके राइट्स को क्योंकि वो भी अफेक्ट होंगे तो उनको भी यहाँ पे हमने लिस्ट किया हुआ है. Then scheduled tribes and other traditional forest developers who have lost any of their forest rights recognized under the scheduled tribes and other traditional forest dwellers recognition of forest rights. तो बेसिकली एक एक्ट ये हमारा 2006 का एक्ट था, जिसके अंदर क्या किया गया था, जिसके अंदर फॉरेस्ट ड्वेलर्स की राइट्स को रिकॉग्नाइज किया गया था. फॉरेस्ट ड्वेलर्स कुछ ऐसी ट्राइब्स हैं हमारे देश में, कुछ ऐसे हमारे शेड्यूल्ड ट्राइब्स होती हैं, कुछ ऐसे हमारे सिटीजन्स हैं हमारे देश के जो फॉरेस्ट में ही रहते हैं, फॉरेस्ट में ही उनका दे फॉरेस्ट ड्वेलर्स एंड दे लिव इन द फॉरेस्ट, अर्न देयर लाइवलीहुड और अर्न देयर एंड सर्वाइव बिकॉज ऑफ द फॉरेस्ट. तो इस एक्ट के अंदर उनको कुछ राइट्स दिए गए थे कि जो फॉरेस्ट है जिसके अंदर आप लाखों सालों से रह रहे हो, हजारों सालों से रह रहे हो, इस फॉरेस्ट में भी आपके कुछ राइट्स हम देते हैं आपको, which are kind of a preserving rights, that we cannot just take away your forest from you because you are dwelling in the forest, you are surviving in the forest. तो इसमें फॉरेस्ट ड्वेलर के राइट्स को उन्होंने प्रोटेक्ट किया था. So basically what we're trying to say is that if any scheduled tribes and other traditional forest dwellers are affected by any land acquisition, then they also need to be compensated. Family whose primary source of livelihood for 3 years prior to acquisition of the land is dependent on forests or water bodies and includes gatherers of forest producers. So basically सबसे पहले तो हमने कहा कि जिनका राइट इस एक्ट में प्रोटेक्टेड है, फिर हमने कहा जिनका प्राइमरी सोर्स ऑफ लाइवलीहुड पिछले 3 साल से इस फॉरेस्ट या वाटर बॉडी से ही था. Then a member of the family who has been assigned land by the state government. So basically state government ने, central government ने अभी किसी को भी पहले कभी land दिया गया था, आज उससे land हम दोबारा से acquire कर रहे हैं, तो he is covered. Then a family residing on a land in urban areas for preceding 3 years or more prior to acquisition of the land, or whose primary source of livelihood for the 3 years prior to the acquisition of the land is affected by the acquisition of the land. So urban areas में अगर किसी का land acquire करेंगे, जो वहाँ पे अपना जिसका livelihood था, जिसका वहाँ पे काम था, if he is affected, then that also is included here. इसमें जो हम बात करते थे प्राइवेट के लिए, कि प्राइवेट पार्टीज के लिए या प्राइवेट कंपनीज के लिए पब्लिक पर्पसेस के लिए अगर कभी लैंड एक्वायर किया जाएगा, तो 80% और 70% वाले क्राइटेरिया के लिए जो कंसेंट ली जाएगी, that is from part 1, that is the family whose land is taken away, and from part 5. तो जो कंसेंट चाहिए होगी उस प्राइवेट वाले सिस्टम के अंदर, that will be required from part 1, that is the family whose land or immovable property has been acquired, and the member of a family who has been assigned land by the state government or central government. इनसे कंसेंट लेने की बात उन्होंने करी हुई है. What is a displaced family? Displaced family means any family who on account of acquisition of land has to be reallocated and resettled from the affected area to the resettlement area. Family का क्या मतलब है इस एक्ट के अंदर? Family includes a person, his or her spouse, minor children, minor brothers and minor sisters dependent on him. तो क्या क्या हो गया, क्या लेग्स हो गए? सबसे पहले बंदा जिसको अफेक्ट हुआ, उसकी स्पाउस या उसका स्पाउस, उसके माइनर बच्चे और उसके माइनर ब्रदर्स और माइनर सिस्टर्स अगर वो उस पर डिपेंडेंट हैं तो. ओके. देन प्रोवाइडेड दैट विडोज, डाइवोर्सीज, women deserted by families shall be considered as separate families. उन्होंने ये कहा कि जो widows हैं, divorcees हैं, women हैं, women who are deserted by their families will not be considered as part of the same family. कई बार disputes होते हैं किसी village के अंदर कि okay, there is a divorcee woman, there is a woman who is a widow. उसकी जो rights हैं उनको separate रखा जाएगा. This is what the act says. Why? So that they are protected. To give them additional protection. That if the widows are dependent on maybe a property that they own, and the sons claim to be owners of that property, then the widow's rights will be separately protected, so that she also gets some financial muscle to preserve her interest. Explanation क्या है? That an adult of either gender with or without spouse or children or dependents shall be considered as a separate family for the purpose of the act. तो अगर एक ही घर है, उस घर के अंदर एक फैमिली रह रही है, उस फैमिली के अंदर एक एडल्ट, एक ग्रैंडफादर है, मे बी ग्रैंडफादर का बच्चा जो है, जो ही इज अगेन हैविंग अनदर फैमिली, तो ग्रैंडफादर की फैमिली सेपरेट मानी जाएगी बिकॉज ही इज अ एडल्ट। ग्रैंडफादर का जो बच्चा है उसकी फैमिली को सेपरेटली रिकॉग्नाइज किया जाएगा। एंड सिमिलरली मे बी 4 generations are living in the same house, so then all the families will be recognized. But this recognition can come from the ownership might be belonging to one family or one person, but because they are living in that house, their uh, their uh, their rights to resettlement and rehabilitation might still be unique, might still be separate. Agricultural land ki definition will include land used. So it means land used for the purpose of agriculture or horticulture, dairy farming, poultry farming, pisciculture, sericulture, seed farming, breeding of livestock or nursery growing medicinal herbs, raising of crops, trees, grass or garden produce, and land used for grazing of cattle. So all these are parts of this is the definition of agricultural land. Marginal farmer means a cultivator with an unirrigated land holding up to 1 hectare or irrigated land holdings up to 1 hectare. तो ये सारी डेफिनेशन हमारे काम आएंगी क्योंकि आगे जाके जब हम इनके राइट्स पढ़ेंगे फार्मर्स के on the transfer of or the acquisition of an agricultural land, there might be some unique rights for a marginal farmer or a small farmer. There might be certain obligations that are required on part of the government to preserve the rights of or preserve the interests of the marginal farmers or a small farmer. Appropriate government means so whenever we talk about this act, it talks about appropriate government repeatedly. So what does an appropriate government mean? So government said that rather than we talking about the various, we have a state government, we have a center government, we have other governments. So rather than talking about all that, we will just define appropriate governments. So basically, whenever the land is situated in situated in the territory of a state, then it says that the state government is the appropriate government. In relation to acquisition of land situated within a union territory, it is the central government. In relation to acquisition of land situated within the union territory of Puducherry, it is different. Why? Because the union territory of Puducherry has a legislative assembly. So therefore, they have given the right to that legislative assembly that for Pondicherry, for Puducherry, that this government, there is a government which is elected by the people. So we will let that elected government decide. In relation to acquisition of land for public purpose in more than one state, the central government in consultation with the concerned state governments or union territories. So पता चला कोई ऐसा acquisition करना है जिसके अंदर part of the land is in Haryana, part of the land is in Delhi. Then the central government becomes the appropriate government and then it consults these respective state governments. In relation to acquisition of land for purpose of union as may be specified by notification, that is again central government, provided that in respect of public purpose in a district for an area not exceeding such as may be notified by the appropriate government, the collector of such district shall be deemed to be the appropriate government. So अगर एक district के अंदर ये acquisition हो रही है तो उन्होंने इसको delegate कर दिया, उन्होंने कहा कि public purpose के लिए एक district के अंदर the collector will be the appropriate government for the purpose of this definition. Cost of acquisition. Cost of acquisition means the amount of compensation which includes solitium. Solitium is compensation which is paid for hardship. Solitium comes from solitary, from solitation. Solitation क्या होता है? Solitation होता है कि आप किसी को आप आपकी कोई हमदर्दी है किसी की तरफ because of some loss that they have incurred. So solitium is a compensation for somebody's loss or somebody's pain. Any enhanced compensation recorded by the land acquisition or so basically the land acquisition and rehabilitation resettlement authority or the court and interest payable thereon. Demurrage to be paid for damages caused to the land and standing crops in the possession of in the process of acquisition. Cost of acquisition of land or building for settlement of displaced or adversely affected families. Cost of development of infrastructure and amenities at the resettlement areas. Cost of rehabilitation and resettlement as determined in accordance with the provisions of this Act. Administrative cost for acquisition of land, including both the project site and out of project area lands, not exceeding. So there is a certain percentage. So there can be some project area, there can be some periphery area. So it says that is the administrative cost for the acquisition. For rehabilitation and resettlement of the owners of the land and other affected families whose land has been acquired or proposed to be acquired for or other families affected by the by such acquisition. Cost of undertaking social impact assessment study. So there is a study which is required whenever an acquisition is required to be done, and that study, the cost of doing that study is also part of the cost of acquisition. Landowner includes, who all do we include in landowner? We include the person whose name is recorded as the owner of land or building or part thereof in the records of authority concerned. Any person who is granted forest rights, we have already talked about this, who is entitled to grant patta rights on the land under any law of the state, including assigned lands, or any person who has been declared as such by an order of the court or authority. Market value. So we will now come to the important part of this act. We need to understand the market value definition of this land, of this act, because market value of the market value definition of this act will influence our thought process with respect to giving any value. If we want to value any such thing in the future, it will also help us understand the land acquisition process. So section 26, which talks about the determination of market value, it says that market value means the value of land determined in accordance with the section 26. So what does section 26 say? So the definition says that you go to section 26 and see what is the value of, what is the definition of land there. What does section 26(1) say? It says that the collector shall adopt the following criteria in assessing and determining the market value of the land. It first talks about the Stamp Act. So various governments have come out with the circle rates or stamp duty rates, where they say that to protect the stamp duty that the government is required to get and to discourage the activity in black money, the state government says that we will only register or transfer this property if it is of a certain consideration. And it basically sets a basic idea that yes, this is the circle rate and all transactions should ideally happen based on the circle rate. So that the stamp duty of the state government is protected. What is the premise? The premise is the state government says that we will expect the property to be valued this much so that our stamp duty is preserved, and the state government then also so that same value can also be picked up for the purpose of this act. The average sale price of similar types of land situated in nearest village or near vicinity area. So now this is also important, that the collector can also adopt the average price or similar types of land situated in the nearest vicinity area. Consented amount of compensation as agreed upon under subsection 2 of section 2 in case of acquisition of lands of private entities. So what is the third value? The third value is what value did so when we talked about the PPP project, we talked about the private companies acquiring land. Subpart C of this definition says that whatever is the amount that has been consented to. So when what happened when the private acquirer of land who wants to set up an industry in that rural area goes to the people who are living in that area and tells them that I want to acquire this land, gets consents. He's getting that consent based on the price that he's offering. Will somebody give consent that okay, you take my land, I'm okay with it, without understanding the price that is coming to them? So the price is important, and therefore the price is also that price that was settled with the private entity or private public-private partner projects is also important. Then whichever is higher. So basically, what is the collector supposed to say? He's supposed to say that whichever of these three values is the highest, that highest value is supposed to be the value for the purpose of determination of market value of the property. So what date? So now the question is that, okay, we know that what is the private, maybe we now know that what is the market value of the property, or what is the market value definition that we have to compute. But market value as on what date? Because market value has to be on a specific date. Market value will keep changing. Before COVID, there was a different market value. Today, there is a different market value for a lot of things, primarily because, primarily based on the impact of those different things. So some explanations which are important. I have represented the complete section 26 because I think it is extremely important for you to understand this section. It will have a bearing on not only the valuations that you want to conduct under this act, but also on other valuations that you're conducting, so that the valuation is done correctly. So section 26, determination of market value. The first explanation says that the average sale price referred to in clause B shall be determined taking into account the sale deeds of the agreements to sell registered for similar types of area in the nearest village or nearest near vicinity area during the immediate preceding 3 years. Explanation 2 talks about for determining the average sale price referred to in explanation 1. For determining the average sale price referred to in explanation 1, 1/2 of the total number of sale deeds or the agreements to sell in which the highest sale price has been mentioned shall be taken into account. Explanation 3 says that while determining the market value under this section and the average sale price referred to explanation 1 and 2, any price paid as compensation for land acquired under the provisions of this act on an earlier occasion on this district shall not be taken into account. So it says that you can't just say that because the government acquired land at the rate of maybe 1,000 rupees a square feet at this area, the subsequent acquisition can also be or should also be done at 1,000 rupees. So it says that should not be. The previous land acquisition record should not be your basis for the value. The basis of your giving any value will rather be the market price as on date, which is computed as per explanation 1 and explanation 2. Explanation 4 says that while determining the market value, it gives the right to the collector so it says that the collector, if the collector is of the opinion that there is that the values that are coming to him or the values of the sale deed are not indicative of actual prevailing market value, then he can discount the same based on his comfort. The value calculated in, so what is the process now? First you calculate this value under subsection 1, then what do? You add based on the factors or based on the multiplication which has been provided for in the first schedule. We will come to the first argument for reason that the land is situated in such areas, remote area, no transactions around the land. In one remote area, no clause A of subsection 1 or similar land are not available. So there is no comparison available. So क्या-क्या चीजें हमने कही कि एक तो land बहुत दूर है और the registered sale deeds or agreement to sales हैं, they as mentioned in clause A of sub rule 1, they are not available. Or the market value has not been specified under Indian Stamp Act. So क्या-क्या चीजें हो गई? ना तो circle rate है, ना ही आपके पास इसके अंदर जो है neither you have any close by transactions in the recent past, nor you have the circle rate. So in that scenario, what happens? The state government concerned shall specify the floor price or minimum price per unit area of the land based on the price calculated in the manner specified in subsection 1 in respect of similar types of land situated in immediately adjoining areas. Determination of then continuing with the section 26, we talk about we talk about certain provisos. We say that this part where the market value is calculated in this way will have some exceptions. It says that there is a proviso that you can't give more than 25% of the value of the land that you are acquiring to the ex-owners. You can't simply tell them that you are becoming partners of a business and give them only shares. Land लिया, share दे दिए, तो पैसा तो आज कोई दिया नहीं. उसको बाहर करने के लिए उन्होंने कहा कि 25% से ज़्यादा के शेयर नहीं दिए जाएंगे. 75% of the total consideration that was required to be paid has to come by way of liquidity, by way of 75% needs to come in from needs to be paid, and balance 25% can only be retained in lieu of share capital. Provided further that the requiring body shall in no case compel any owner of the land whose land has been acquired to take its shares. Provided also that the collector shall, before initiation of any land acquisition process in the area, take all necessary steps to revise and update the market value of the land on the basis of prevalent market rate. Provided also that the appropriate government shall ensure that the market value determined for acquisition of any land or property of an educational institute established and administered by religious or linguistic minority. So basically it is also to preserve any minority educational institutions. Here's the first schedule which we were talking about. So what all are the parts? The parts are, the first we talk about the market value of the land, and this schedule also says that you compute market value based on section 26 that we just read. Then it talks about factors by which the market value is to be multiplied in case of rural areas. So in rural areas, the multiplication, so whatever is the certain market price, that now needs to be multiplied with a factor. If you are aware of house tax returns, there are various factors that are involved. Commercial use कर रहे हो तो 4 का factor लगाओ, self use कर रहे हो तो 4 का factor लगाओ. इस तरीके से अलग-अलग factors होते हैं to change the value. तो हम क्या करेंगे, हम urban areas में तो 1 का factor लगाएंगे, और रूरल एरियाज हैं उसमें 1 to 2 के बीच में डिसाइड करेंगे based on the perception based on the market. So in case of urban areas, the 2 option is not there, only 1 option is there, that is you will only get your market value. Then there are values, then there is solitium. Solitium cannot exceed 100% of the amount that has been decided as rural slash rural land or urban area, and that 100% is required to be paid. Final award in rural areas, market value of land mentioned. So basically what happens is that the market value of the land in serial number 1 multiplied by the factor in 2 plus the value of assets attached to the land or building, all this becomes the final award in rural areas. So basically it has been defined so that it can be referred to as final award in our rural areas, and it can be defined as final award in urban areas without any dispute. So when we do this valuation, when we do this acquisition, we are valuing the land as per section 26. But what about other things that are attached to it? So for that, there is section 29, which says that, which tells us how we will need to determine the value of things attached to land or building. So please note that things attached to it should not be read as things attached to land or it should not be read as things attached to the it should not be read as things attached to the building. So basically what we're trying to say is that there are different parts to it. There is a land, on that land maybe there is a building. So now the building is also now part of that land. So the building also needs to be compensated for. Then there can be also other things which are attached to the land, like crops. Maybe some of you can give us more examples. So after this section, we will briefly take a question break, and I will try and answer some questions. So what is the first part of this determination of value? First part is the market value of the building and other immovable property or assets attached to the land or building. तो सबसे पहले क्या किया आपने? सबसे पहले 26 में आपने land की market value निकाल दी 26 में. अब 29 में आ गए आप. 29 में आप क्या कर रहे हो? आप कह रहे हो सबसे पहले what is the market value of the building that is constructed on that land, number 1. Then it says apart from the building, you might have certain things which are attached to the building, and you might have certain things which are attached to the land. अब एक एग्रीकल्चरल लैंड होगा तो एग्रीकल्चरल लैंड में हो सकता है गेहूं उग रही हो, तो फिर उस वो जो गेहूं आपकी डैमेज होगी because of the acquisition, you need to compensate for that. Similarly, in case there is maybe, let me take another example. Maybe there is a house constructed on that land, and that house has something attached on it, which is very crucial, which is reasonably expensive. So in that case, what you will do is you will value that building as well as the other things that are attached to the land separately. Land you have valued separately. All these purposes you will deal with separately. The collector, for the purpose of determining the value. The collector, for the purpose of determining the value of trees and plants attached to the land acquired, use the service of experienced persons in the field of agriculture. And then there can be, what can be there is that those whatever land you're acquiring might have some value in the form of somebody using them for service, for somebody using them. So that value of trees and plants, the value of standing crops is required to be added to that under section 29 to the value of the building. So any questions so far? Let's try to communicate a little so that we keep this interesting for everyone. Yes, Vikas ji.
सर, हम जिनसे लैंड लेते हैं, अभी शुरू में हमने बात करी थी, फॉर एग्जांपल फार्मर्स, तो उनको रीइंस्टेट करने के लिए हम किसी दूसरे फार्मर से भी ले सकते हैं. तो ये चेन कहाँ होती है जाके?
So when there is a social impact scheme, तो social impact के अंदर ये देखा जाता है कि एक एरिया के अंदर आप मान लेते हैं एग्रीकल्चरल लैंड किसी से ले रहे हैं, तो अब उस फार्मर को आपने डिस्प्लेस तो कर दिया, तो एक स्कीम ऐसी होती है कि उस फार्मर को इतना लैंड हम देंगे. अब वो लैंड कहाँ से मिलेगा, उसके लिए फिर अलग से एक प्रोविजन बनता है दैट डिस्प्लेसमेंट कम से कम हो, उसके लोकल एरिया में हो, साथ वाले गांव में हो जाए, किसी और तरीके से उसको किसी तरीके से लैंड मिले.
तो हम थर्ड पर्सन से एक्वायर करते हैं उसको देने के लिए.
तो बेसिकली वो जो एक्विजिशन नॉर्मली प्लान होती है सेकंड पर्सन से टू अलाउ रीसेटलमेंट ऑफ द प्राइमरी पर्सन, normally that is done from maybe people who have large land holdings,
part of land उनसे लेते हो,
or maybe from land holdings that are owned by the government itself, or maybe land holdings that are under some other use. So normally they try to displace as little as possible.
Right, sir.
Therefore, it becomes a very powerful thing that it becomes the collector is responsible and the scheme is responsible. Maybe somebody will displaced, somebody will not be displaced.
Sir, one question.
Yes, Mr. Chinda.
Sir, regarding that percentage, 80% and 70%, only the landowner will be asked to participate in that percentage this one, to vote that one, that whether the other, that like farmers or a tenant, they are not empowered in that to say their opinion.
There are two parts to it, sir. There are two parts to it. The general thought process is that the compensation for the market value of the land is, or the primary displacement is happening for the owner of the land. This is the presumption, and basically that is why you take their consent, because they are the people who are transferring. So what is happening in this part is, I will just come back to this slide. What is happening in this part is that you're saying that because of this PPP project or because of this private company trying to acquire this land, you already the consent is a prerequisite. So who consents? The consent is primarily required from the owners of the land or from the people who have been allotted land. The other people who are dwelling on that land, maybe there is a tenant, maybe there is a laborer, maybe there are other people, they are being compensated for the displacement. They are being rehabilitated primarily. Their compensation will not be maybe different from the person whose land is taken away. There are multiple parts. There are multiple acts that are causing a problem. One act is that you are taking something which is somebody's and taking it from that person. That is the land acquisition primarily. Then you're talking about compensation for displacement, compensation for rehabilitation, compensation for resettlement. So these compensations, which are the secondary part, resettlement, rehabilitation, all that, will be the primary compensations given to those people who have their livelihood coming in from that land. So their compensation will not be equal. The compensation to the first person, being the landowner, will be for everything. that is land ownership, rehabilitation, resettlement, loss of opportunity, whatever. For the purpose, for the other people who are also people who are affected, which include, if you talk about part number 2, part number 3, part number 4, and part number 6.
Yeah.
They are being compensated not for the loss of land, but loss for the opportunity that they had when they had the land to themselves.
But in the opinion poll, they are not being considered. Only the owner has been considered.
Yes, because when you talk about consent, if you talk about everyone's consent, that you start giving consent to the tenant, or you start giving power to consent to the laborer, then there will be very, very difficult. It will become increasingly difficult for the project to go ahead. Because see, what happens is that whenever you're acquiring a land, say I today as a private person want to acquire an agricultural land, I go to that person, I say, "Aap ye mujhe land beech do," and I can acquire that land without compensating other people, without compensating the laborer, without compensating other people, because maybe I will ask him कि आप अपनी tenancy खुद settle करो, मैं तो आपका land acquire कर रहा हूँ. I am not here to settle your tenancy separately, right? So all those people who are having their day-to-day activity coming in from the land are being compensated only where the government is acquiring the land, not where the private person is doing it. If I do today as a private person go, I will not be liable to compensate everyone there.
Sir.
Or I'm compensating for the displacement.
Sorry.
Yes, sir. Yes, Malik sir. Agarwal ji, I will take your question next.
सर जैसे कि लैंड को एक्वायर किया, उसमें कोई बिल्डिंग है, तो बिल्डिंग को कैसे कंपनसेट करेंगे? एग्जिस्टिंग कॉस्ट को बिल्डिंग का देंगे, उसके रीसेटलमेंट का भी देंगे नेक्स्ट प्ले, अगर किसी दूसरी जगह पे उसको बनाना है तो, या डिसमेंटलिंग कॉस्ट किसका पार्ट रहेगा?
So basically जो भी बिल्डिंग की वैल्यू है, वो उस बिल्डिंग की वैल्यू, जैसे हमने सेक्शन 29 पढ़ा था, तो सेक्शन 29 के अंदर बिल्डिंग की कॉस्ट भी निकलेगी. और हमने जैसे ये कहा कि इसके अंदर अगर किसी कॉम्पिटेंट इंजीनियर की जरूरत पड़ेगी या अदर स्पेशलिस्ट की जरूरत पड़ेगी, तो उसको कलेक्टर को उसको अपॉइंट करना है, क्योंकि यहाँ पे ये अज्यूम किया जा रहा है कि कलेक्टर मे नॉट अंडरस्टैंड कि बिल्डिंग की वैल्यू क्या होनी चाहिए. प्राइमरीली यहाँ पे जो मेथड यूज होता है बिल्डिंग को वैल्यू करने का, वो तो यही होता है कि इस बिल्डिंग को अगर आज बनाया जाए दोबारा से, कोई अगर ऐसी बिल्डिंग आज दोबारा बनाए तो क्या कॉस्ट आएगी, एंड बेस्ड ऑन द एज मे बी प्रोवाइड फॉर ऑब्सोलेसेंस.
और उसका डिसमेंटलिंग कॉस्ट वगैरह वो गवर्नमेंट का पार्ट रहेगा ना?
डिसमेंटलिंग कॉस्ट जो होगा वो तो मतलब ये नहीं कहा जाता कि डिसमेंटलिंग कॉस्ट वाला काम जो है उसमें से माइनस होना चाहिए और समथिंग लाइक दैट. डिसमेंटलिंग से अगर डिसमेंटलिंग का जो काम है वो तो वही करेगा जो प्रोजेक्ट को आगे टेकअप करेगा. ये एक्सपेक्टेशन तो शायद नहीं होती लैंड एक्विजिशन के अंदर कि लैंड के ऊपर सारी बिल्डिंग हटा के लैंड दिया जाएगा लेने वाले को. But that cost of bringing down that land perhaps can be part of the total project cost that we're talking about.
One question: where the role of public hearing will come in case of that taking opinion poll, public hearing?
It is there, sir. It is there in the process. Public hearing or public notice or public discussion, public forum में present करना पूरे के पूरे plan को. It is part of the act. I will come to it.
If any land is taken for public sector undertaking, does they fall under this opinion poll, PSU?
आप 80% कंसेंट की बात कर रहे हैं शायद.
हाँ सर, हाँ सर.
नहीं सर, नहीं वो नहीं आएंगे सर, वो पार्ट 1 में कवर हो गए. वो पार्ट 1 में कवर हो गए. ये देखिए वो पार्ट 1 में ही कवर हो गए. वो यहीं पे कवर हो जाते हैं. PSU यहीं पे लिखा हुआ है उन्होंने इंक्लूड.
PSU.
So PSU is not a part of part 2. Part 2 is for others.
सर ये पत्ता राइट बताया आपने, ये क्या है?
तो कुछ स्टेट गवर्नमेंट्स का सिस्टम होता है कि वो पत्ता राइट्स देते हैं. देयर इज अ सिस्टम दैट इफ आई हैव अ लैंड एंड आई एम नॉट एक्टिवली यूजिंग इट, I can apply for a patta right, and the government basically gives me a document to say that you are the owner of this land, even if you are not using it. जैसे हमारे यहाँ पे जो रूरल रिकॉर्ड्स होते हैं, उन रूरल रिकॉर्ड्स के अंदर मल्टीपल रिकॉर्ड्स होते हैं. एक होती है एक फर्द होती है, फर्द करके एक डॉक्यूमेंट होता है, पटवारी के रिकॉर्ड्स होते हैं. Basically, if you talk about British times, there were many interesting. When I was playing recently to Europe, there are a lot of places which display old land records, and it is widely believed that humans discovered writing. Primarily, the first use of the writing was done to create land records, and that was one of the chief drivers. So you understand the importance of land record, that it was so important for human beings to record land ownership on paper, and that ownership or those records were primarily created not to preserve the land ownership but to tax them. So whoever used to control any piece of land, whenever he became a larger ruler or for a larger community, उसको लगता था कि अब मैं अपना प्रोटेक्शन कैसे करूं. तो जब उसको डेलीगेट करना होता था ये टैक्स कलेक्शन का प्रोसेस, then they had to rely on land records. That टैक्स कौन देगा? टैक्स वो देगा जो लैंड ओन करता है. दूसरा, फिर उन्होंने कभी ना कभी ये कहा कि टैक्स कौन देगा? टैक्स वो देगा जो एग्रीकल्चर कर रहा है इसके ऊपर. हो सकता है लैंड ओनरशिप किसी और के पास हो, एग्रीकल्चरल प्रैक्टिस किसी और के पास हो. तो पुराने जमाने में, आज से 2000 में, मे बी फ्रॉम टाइम इंडेफिनेट, कोई ऐसा सिस्टम होता होगा कि अगर आपने इतना, जैसे वो लगान पिक्चर देखी होगी, तो लगान में वो कहता है कि इतने परसेंटेज ऑफ आपका जो कल्टीवेशन है वो सरकार का हो जाएगा. बेसिकली दैट इज लगान, दैट इज द टैक्स दैट वी आर टॉकिंग अबाउट हियर. लगान इज अ वेरी वेरी ओल्ड सिस्टम. Interestingly, land records are something that was one of the first creations or first documents available in writing in various civilizations. These are the main records that are found whenever somebody says that, okay, we found these land records. That means that this civilization found writing or started writing their documents at that point in time.
So can I add one thing about patta rights?
उसको पटानामा कह देते हैं. हिमाचल और पंजाब में उसको पटानामा वर्ड इस्तेमाल करते हैं. पटानामा.
सर जो पटास होते हैं, सॉरी सर,
प्लीज गो अहेड सर.
बांसल साहब बोल रहे थे कुछ, प्लीज.
नहीं, बोलिए सर. बस मैं वो बोल रहा था कि पंजाब में उसको पटानामा कहते हैं.
हाँ जी सर, जो हमारे पंजाब में पटास थे ना, एक्चुअली पट्टास, PATTA, वो the people who were not the original land holders, they were marginal people of the society, उनको थोड़ा थोड़ा piece of land दे दिया जाता था, तो that was called पटा. One thing is this. Another is वो कहते थे मैंने तेरे नाम पटा लिख दिया, तू को पटा लिखा कर लेकर आया है. इसका मतलब क्या था? वो अनऑफिशियली विलेज पंचायत की तरफ से लिख कर दे दिया जाता है, दिस स्मॉल पीस ऑफ लैंड जिसके ऊपर तुम अपना रूढ़ी रख सकते हो, घर का कोई पशु बांध सकते हो, दैट इज पटा फॉर यू.
So basically जो कॉमन यूजेज में एक वर्ड चला जाता है, जैसे ओरिजिनली हो सकता है कोई ना कोई लीगल अथॉरिटी, कोई ना कोई राजा, कोई ना कोई सुपीरियर अथॉरिटी ये पट्टा अलॉट करती होगी कि अच्छा मैंने तेरे को ये पट्टा दिया तो इस पे ये काम कर सकता है, तेरे को राइट दे दिया मैंने ये.
ओके, तो ये
आज की डेट में तो कॉमन पार्लेंस में भी आ गया. जैसे सर ने कहा कि एक प्राइवेट आदमी भी एक और आदमी को पट्टा दे सकता है, मैंने तेरे को पट्टा राइट्स दे दिए, तो वो कॉमन पार्लेंस में वर्ड यूज हो गया. यहाँ पे जो हम बात कर रहे हैं, वी आर सेइंग दैट हु इज एंटाइटल्ड टू बी ग्रांटेड पट्टा राइट्स ऑन द लैंड अंडर एनी लॉ ऑफ द स्टेट. राइट, वी आर वेरी वेरी स्पेसिफिक अबाउट पट्टा राइट्स अंडर द लॉ ऑफ द स्टेट.
ये वही चीज है जो हिमाचल में जैसे हम पट्टा अलॉट करती है गवर्नमेंट, ये वही है ना?
हाँ, गवर्नमेंट जो अलॉट करती है पट्टा, ये उसकी बात कर रहे हैं.
ओके, थैंक यू.
Sir, hello.
जी सुरेंद्र जी.
Sir, when it comes to rural area, you said the market value has to be multiplied by some factors which lies between 1 and 2. What is the reason behind that, and how to decide that factors?
The thought process of the government is that whenever a rural land is purchased from somebody who is maybe doing agriculture there, maybe doing some kind of animal husbandry there, the thought process perhaps is that that market is not very well developed, or maybe the thought process is that there can be an error in the form that maybe the said land, if traded for the same purpose, would have given a different value, but now that because it is industrial used for industrial use, it will certainly increase in value. Basically, if you read this, so you understand the reason why this is 1 to 2. by understanding that it says that 1 to 2 based on the distance of the project from the urban area as may be notified by the appropriate government. So it can be 1 in case that land is very, very close to an urban area and almost urbanized. But it can be 2 if it is absolutely rural area. Because what you're trying to do is that the market value that you're coming out in serial number 1 might be the market value of an absolutely rural exchange. But because you're urbanizing it, because you're industrializing it, because you're using it for some public purpose, then there has to be a factor involved in it. Or maybe you have to, the thought process is also that whoever you will be taking this land from, maybe that person is required to buy land at a more expensive rate. Because now that that property or that place is a little developed, wherever he will go and try and buy something to keep his livelihood, to maybe rebuild his house, to maybe start agriculture to practice again, he might have to spend more money. But whereas in an urban area, in case you are displaced from your house today, the adjoining areas or you might have several opportunities to buy the property at the same price at some other place in the same city.
One clarification required. Solatium, you have mentioned equivalent to 100% of the market value.
Right, sir?
Hello.
Yes, sir.
In the first schedule, against point number 5, Solatium. Solatium, you have mentioned equivalent to 100% of the market value of the land mentioned.
Right.
Against serial number 1 multiplied by the factor so and so.
Yeah.
That means you mean to say if all this multiplying their factor, if it is comes say 100 rupees, the Solatium will be 200?
No, Solatium will be 100 only. So basically the total payout to the person I'm acquiring the land will be Solatium plus the market value. So if I'm acquiring land in an urban area, I will be effectively paying twice the price or 2 times the price of the market value or 2 times the market value of the land.
Yes.
But whereas if I'm requiring the land in rural area, it can be anywhere between 2 to 3 times. Any other question? Any other input from anyone? Because all of your land and building valuers, you might have come across some circumstances where you have had some practice in land acquisition. You can share your experience. Yes, Malik ji.
सर जैसे रिलीजियस स्ट्रक्चर है, जैसे कोई टेम्पल है, मॉस्क है, तो उसको एक्वायर करने का क्या वो है और उसको कैसे कंपनसेट करते हैं?
My thought process, sir, is that whenever there is a use of a land which is for this kind of a purpose, maybe there is some trust which owns that temple. Maybe there is some society or some people who own that temple together. And whenever that land is acquired, the idea is that they will have to relocate that temple, and they will have to perhaps reconstruct that temple. So that is the basis on which the valuation should be done, because you are assuming here that whoever is being compensated under this act will need to put in or invest that money to recreate the same thing at maybe a place close by or a place which is in some adjoining area.
Nowadays,
सर
hello.
एक टर्म एक यूज होता है सर रेवेन्यू में, डिमार्केटेड फॉरेस्ट एंड अनडिमार्केटेड फॉरेस्ट, ये क्या है, इसमें क्या डिफरेंस है?
I think there's certain forest acts जो होता है, जो forest preservation के acts होते हैं, उसमें कुछ forests को demarcation का एक system होता है. You demarcate and you say that these are notified forests. And there are certain undemarcated forests where there might be maybe a forest, but that forest may not be in that a part of that list of forests that is given some protection by the Protection Act. So that will be demarcated forest and undemarcated forest. The idea of recognizing undemarcated forest will be to preserve and to provide for the replantation of those trees. Because whenever you are using that land for an alternative purpose, you have to provide for there are 2-3 things that the government checks whenever there is a forest area which is involved in an acquisition of land. One is that they check if there is an alternative. Like, you know, if there is an alternative where that forest can be avoided and the acquisition can take place in an alternative area, then that is an alternative. But say there is a road that has to go through an area, and that there is no other way for that road to go and reach the destination, or if you create an alternative route, then that alternative route is too long. In that case, if the forest comes in the middle, then the forest needs to be also acquired for that highway. The idea is that generally you will avoid it, but if you can't avoid it, then you have to compensate by planting equal number of trees to preserve the environment.
So one question please.
Yes, sir.
सर अगर किसी विलेज एरिया में रूरल एरिया में एक्विजिशन होना है एंड मेजॉरिटी ऑफ द लैंड इज एग्रीकल्चरल बट सम लैंड्स हैव बीन कन्वर्टेड इनटू नॉन एग्रीकल्चरल लैंड यूज मान लीजिए किसी ने कोई चक्की लगाई या ऑयल एक्सट्रैक्शन प्लांट छोटा सा लगाया और बैंक से लोन लेने के लिए उसने सेक्शन 143 में उसको नॉन एग्रीकल्चर में कन्वर्ट कर लिया तो एक्विजिशन में कौन सा रेट
CLU ले लिया ना उसने, CLU ले लिया आप कह रहे हैं.
हाँ, तो अब एक्विजिशन आया.
The land that is acquired by the government under this act will understood to be for the current use, for the use that was already happening.
की सेवा.
और मेरे पड़ोसी को तो हेक्टेयर्स में रेट मिल रहा है और मेरे को मीटर्स में मिल रहा है.
पैसे टोटल किलो.
हेक्टर्स मीटर्स तो सिर्फ यूनिट की बात हो रही, बट पॉइंट
है सर्कल रेट कन्वर्ट हो जाता है ना नॉन एग्रीकल्चरल होते ही. जो सर्कल रेट होता है वो जैसे कन्वर्ट करता है लैंड इट बिकम मीटर्स और वो ज्यादा होता है.
Got your point. So what I'm trying to say is that agricultural land which is close to an urban area also normally fetches a higher market value, and that higher market value comes from the thought process that maybe because this is close to urban area, it will be urbanized at some point in time in future.
सर मेरी पूरी रूरल एरिया में है. आई हैव कन्वर्टेड इट इनटू नॉन एग्रीकल्चरल लैंड यूज एंड माय सर्कल रेट इंक्रीजेस बाय से 10 टाइम्स ऑफ द एडजॉइनिंग लैंड. तो क्या एप्लीकेबल होगा मेरे को? कौन सा रेट मिलेगा सर्कल रेट?
मेरा थॉट प्रोसेस तो यही है सर कि सर्कल रेट उस लैंड यूज के लिए देखना पड़ेगा. जो लैंड यूज
को मिल रहा है 10 लाख रुपए हेक्टेयर, मुझे मिल रहा है 10,000 रुपए स्क्वायर मीटर.
Sir, the point is that CLU that was granted to that unit is increasing the value of that adjoining area.
Theoretical value, practically नहीं है. Practically तो हेक्टेयर्स में ही है रेट. Theoretically मेरा
अच्छा practically बात करते हैं. Practically के अंदर जो जिसमें इन्होंने बात करी कि practically जो रेट निकालने के लिए बात करते हैं, हम practical बात करते हैं, तो हम कहते हैं कि हमें ये 3 चीजों का ख्याल रखना है. सबसे पहले मार्केट वैल्यू एज पर दी स्टैम्प एक्ट, तो हम अभी इसकी बात कर रहे हैं आपके साथ. Then there is an alternative that is the average sale price of similar type of land situated in the near vicinity area. अगर कोई भी लैंड उस एरिया के आसपास खरीदा गया है which was agricultural land but which was acquired and it was very close to that CLU transferred or CLU changed land, then most probably you will be your interest will be covered under part B. राइट,
मतलब एग्रीकल्चरल वाला रेट लगेगा.
एग्रीकल्चरल वाला रेट लगेगा सर फर्स्ट पार्ट के लिए, जब आप इंडियन स्टैम्प एक्ट के अंदर सर्कल रेट को चेक कर रहे हो. और जब आप मार्केट रेट को चेक करोगे तो मार्केट के अंदर तो उस CLU चेंज लैंड के आसपास जो भी एग्रीकल्चरल लैंड है उसके अंदर अगर कोई भी ट्रांजैक्शन हुई है किसी के साथ भी, तो वो
एग्रीकल्चरल रेट पे हुई होगी,
वो एग्रीकल्चरल के ऊपर ही हुई होगी. बट उसका जो मार्केट प्राइस है वो तो ऑलरेडी बढ़ के मिला होगा ना किसी को, अगर वो CLU लेने के बाद बिका है तो. You understood my point that अगर एक एरिया डेवलप हो गया, उस एरिया के आसपास का जो
डेवलप नहीं हुआ सर, बिल्कुल इट इज हार्ट ऑफ द रूरल एरिया.
चलिए डेवलप नहीं हुआ बट CLU तो है
सर. वो मेरा है ना, मेरे पड़ोसी का नहीं है.
आप कह रहे हैं कि CLU आपको मिल चुका है और आपका लैंड एक्वायर हो रहा है आफ्टर CLU.
दोनों का हो रहा है जो जिसमें CLU है, मेरे पड़ोसी का भी हो रहा है जिसका एग्रीकल्चरल है.
तो जहाँ पे CLU मिला हुआ है वहां पे मेरे हिसाब से जो स्टैम्प एक्ट के अंदर जो भी वैल्यू आएगी दैट विल बी बेस्ड ऑन द चेंज्ड लैंड यूज.
yes
and the market value will be based on the equal land use in the vicinity. So there will be some difference in case you have a CLU. There is no doubt about it in my head. CLU does add value to the land in my opinion because it is allowing the usage for some alternative purposes.
होना क्या क्या आवाज आ रही है?
Any further questions?
अग्रवाल साहब म्यूट करिए प्लीज, थोड़ा सा अपना सेट म्यूट पर करिए प्लीज.
Any further questions on whatever we have discussed so far? So I will quickly now run through the acquisition process. The acquisition process starts from section 4. It starts with preparation of a social impact study. It then includes the public hearing for social impact study, where the study is presented or study is discussed with the local people who will be affected by the acquisition. Then the social impact assessment study is published in 2 newspapers, and then there is a proper publication on the website also. Then appraisal of social impact assessment report by expert group. Then examination of proposals for land acquisition and social impact assessment report by appropriate government. Exemption from social impact assessment. There are certain parts in case of urgent acquisitions where social impact assessment has been exempted or can be skipped. And special provisions to safeguard food security. So this section talks about how irrigated land where where irrigation is, or where agriculture is done on a multi-crop basis, is protected, so that the food security is does not come under danger. Then publication of preliminary notification and power of officers thereon. So when section 11, when this publication of this preliminary notification is done, the valuation date is deemed to be the date of this public notification. So before that, all the process is something that you should understand, because maybe somebody will come to you as an expert, maybe because you're an expert engineer, and say that please value this building for the land acquisition process. At that point, you need to understand that the valuation date is this section 11 date. And you also will like to understand that what is the process that has happened already. So maybe all these documents are already available in public platform for you to go through and for you to understand and for you to base your valuation report on.
फ्रेंड्स कंसंट्रेट करिए, ये क्वेश्चन बहुत बार आया है, व्हाट इज द डेट ऑफ वैल्यूएशन अंडर लैंड एक्विजिशन एक्ट. बहुत बार आया है, बहुत बार, लगातार कई बार आता है. इसको याद करिए. सेक्शन 8 इसको क्रैम करिए. पब्लिकेशन ऑफ एडवर्टाइजमेंट.
So section 11 mein, this is important. Then section 12 is primary survey of land and power of officers to carry out survey. Payment for damage under section 13. Section 13, section 14 में lapse of social impact assessment report. इसमें ये लिखा हुआ है that if 12 months go by from the social impact assessment report, then it lapses. You have to now do a fresh social impact assessment study. Then preparation of rehabilitation and resettlement scheme. So that is your preparation of rehabilitation resettlement scheme by the administrator, review of rehabilitation and resettlement scheme by the collector, approved R&R scheme to be made public, publication of declaration and summary of rehabilitation resettlement. So all this is the process, and this goes on. Then land needs to be marked out, measured and planned, including marking of specific areas, notice to the persons interested, power to require and enforce the making of statements as to names and interest, inquiry and land acquisition award by the collector, land acquisition process under act number. So basically it talks about whatever process that had happened under the previous act, what happens to it, period within which an award shall be made. So that is that it has to happen within 12 months from this section 19. So whenever this publication of declaration and summary and rehabilitation happens, the award has to be made within 1 year or within 12 months from that. Period within which an award shall be made. Determination of amount of compensation is under 26. So then we talk about 26 onwards, we talk about how we are already talking about market value. We've already discussed it. Section 27 talks about determination of amount of compensation. 28 is very, very interesting. 28 is talking about these parameters. So I will come back to this because I think this is where we talked about. So this is where we stopped at section 29. So these are the parameters that will be considered by the collector in determination of the award. What all does he need to look into? He will firstly look into the market value as determined under section 26 and award amount in accordance with first and second schedules, number 1. Secondly, then he will look at the damage sustained by the persons interested by reason of taking of any standing crops and trees, which may be on the land at the time of collectors taking possession. Then he will see that land अच्छा एक बंदे के पास था, फिर वो कहेगा कि अच्छा ये crop किसके थे, ये पेड़ किसके थे, ये crop और पेड़ जिसके थे उसको compensation देने की कोशिश करेगा. Then thirdly, he will talk about the damage sustained by the persons interested at the time of collectors taking possession of the land by reason of severing such land from his other land. तो ऐसा हो सकता है कि एक लैंड मेरे पास था, मैंने जब उसको सेवियर किया किसी के बचे हुए लैंड के साथ, तो उसको बाउंड्री वॉल बनानी पड़ी दोबारा से. Then maybe that damage or that loss to him will be compensated as the third part. Fourthly, the damage, if any, sustained by the person interested at the time of collectors taking possession of the land by reason of the acquisition, injuriously affecting his other property, movable or immovable, in any other manner, or his earnings. तो एक ये चीज हो सकती है कि मैंने लैंड एक्वायर करने की कोशिश करी, जो भी रीजन था मेरा, उसकी वजह से उसकी अदर प्रॉपर्टी पे जो क्रॉप था वो भी खराब हो गया, या उसकी अदर प्रॉपर्टी के ऊपर जो वो अर्निंग कर सकता था वो नहीं कर पाया. He could not cultivate his land or could not harvest his land because I had taken over his land. So that will also be covered. Then fifthly, in consequence of the acquisition of the land by the collector, the person interested is compelled to change his residence or place of business. Then the reasonable expense incidental to such change. अगर मैंने किसी को फोर्स किया कि भी तुम्हारा मैं घर ही ले रहा हूँ या मैंने तुम्हारा प्लेस ऑफ बिजनेस ही ले लिया, तो मुझे ये कंपनसेशन भी उसको देनी पड़ेगी. Then sixthly, the damage, if any, bona fide resulting from diminution of the profits of the land between the time of the publication of the declaration under section 19 and the time of collectors taking possession. तो अगर possession बाद में हुई और पहले notification आ गई और मैंने कहा कि यार अब तो ये land acquire ही होने वाला है, पता नहीं कब हो जाएगा, और मैंने उस टाइम पे वो 3 महीने 4 महीने 6 महीने जितना भी टाइम था, मैंने उस टाइम पे उस पर खेती नहीं करी, तो गवर्नमेंट कहती है कि हम आपको उस टाइम के लिए कंपनसेट करेंगे क्योंकि आपका लैंड हमने पहले आपको बोल दिया था हम एक्वायर करेंगे. तो जब किसी को बोल दिया जाता है कि आपका लैंड हम एक्वायर करेंगे, तो आप उस लैंड के ऊपर इन्वेस्टमेंट थोड़ी ना करते हो, आप उस लैंड के ऊपर क्रॉप थोड़ी ना उगाओगे नया, आप उस लैंड के ऊपर एक नई बिल्डिंग थोड़ी ना बनाओगे. तो जो भी आपका अर्निंग लॉस हुआ है वो आपको कंपनसेट किया जाएगा. एंड सेवेंथली, any other ground which may be in the interest of equity, justice and beneficial to the affected families. जिन लोगों को कोई इफेक्ट हुआ, जिन फैमिलीज को कोई फर्क पड़ा, उनको भी कोई ना कोई पैरामीटर किसी तरीके से कंपनसेशन दी जाएगी. So these parameters are considered. In section 29 there is a determination of value of things attached to land or building, हमने already discuss कर लिया है इसको. Then section 30 में award of solitium, corrections to awards by the collector is 33, and similarly then the process goes on. Then there is appellate process, there is other detailed process which you can always go through, but which is not core to the requirement of our current discussion. Sandeep ji, anything as part of this that I have not covered which might be asked in the examinations?
नहीं sir, almost सभी cover topics हो गए हैं इस सेक्टर के रिलेटेड.
Perfect. So I think then now we can take a short break.
Yes sir. Yes,
and
sir.
then we can come back and then we can start with the
very
next
much necessary.
So we will resume at about how much time should we take, Sandeep ji?
सर आप देखिए जितना आप परमिट करेंगे उतने टाइम के बाद हम लोग it can be up to half an hour also.
Okay, so let's meet after half an hour then, not a problem.
Yes, अभी तकरीबन 11:05 हुए हैं, हम 11:30 बजे मिलेंगे सर.
ठीक है, 11:30 perfect.
Convenient है सर?
11:30 is perfect then. 11:30 we meet up again, everyone.
जी बिल्कुल सर, बिल्कुल. So friends, we will take a short break for morning tea up to 11:30. We will rejoin at 11:30. Till then you can switch off your screen if you want.